Let's give Justin a second to join us, and then we will go ahead and get started. Looks like he's on here. Let me go ahead and get started with our best practices in design searching. The CLE today will be focused specifically on design searching, which is very, very different from keyword searching, utility searching. We have wonderful panelists with us today that we will introduce in just a moment. Just to start off with myself, my name is Amir Ahmed. I'm a senior patent analyst here with Legal Advantage. Graduated from George Mason University and spent the first 7.5 years at the patent office as a search specialist, helping the examiners find prior art when they're not able to find it themselves. Also help teach the new hire examiners into how to conduct a search, setting up for a good search technique, where to find keywords, the databases to be able to go in and search. Along with us as well is Jeff Sobek. He is our VP of Sales and Marketing. He has a BA of Business Administration from Illinois Wesleyan and received his JD from John Marshall Law School, and at this point has well over 12 years of sales experience in the technology marketplace. On to our panel, our wonderful panel. Thank you, gentlemen, all for taking the time to join us today. We have Dunstan Barnes from McAndrews and Howard, PhD in Material Science and Metallurgy from the University of Cambridge, has JD from Chicago Kent College of Law, current chair of the ABA Design Rights Committee, current chair of the AIPLA Litigation and Enforcement Subcommittee of the AIPLA. Along with us is Justin DeAngelis from Quarles and Brady, received his BS in Mechanical Engineering from the University of Wisconsin-Madison, as well as his JD from Chicago Kent College of Law, current chair of the AIPLA International Policy Practice Subcommittee of the AIPLA Design Committee. As well with us is Jeremy Kriegel from Marshall Geerstein, received his Bachelor's of Science in Mechanical Engineering from the University of Rochester and his JD from Washington University School of Law. Selected as leading lawyer by his peers multiple times in multiple categories. The one we wanted to highlight is the Law Bulletin Publishing Company. Dunstan Barnes, would you like to just give us a short intro into yourself and what you've been working on recently and how this working from home has treated you?
Yeah, sure thing, Amir, and thank you to you and Jeff and the rest of the Legal Advantage team for having us today. Yeah, I've been focusing in design rights for probably about 6 years now. I think I got into the space after an attorney I was working for had a large number of design patents. I think it was like over 30 he needed to file in one day, and at that point I'd sort of worked on one, I think, and anyways, it went off without any major hitches. So, and I sort of enjoyed working in that space, and so it's just kind of grown from there. So these days, it's probably, certainly it's the majority of my work is in design patent for preparation, prosecution, and sort of protection strategy, I would say. I do also do utility patent prosecution and some enforcement, but certainly design patents is kind of the main focus. I guess your other question was how the remote working has been. I mean, I guess for the most part, it's been relatively seamless. I guess I'm thankful to have a dog to walk every day, so at least I get outside and get a little bit of fresh air. But you know, obviously staying physically distanced from other people. But yeah, you know, just staying healthy, sane, and safe, trying to flatten that curve. But otherwise, I mean, work carries on as usual. So people are continuing to file for and protect their designs. So I've been carrying on that front.
Thank you very much, Dunstan. Justin, are you with us?
Hey, Amir.
Hello.
Can you hear me?
Hey. Yes, we can hear you.
Hey, so I've been doing design work basically since I started at my current firm at Quarles and Brady. I did a little bit while I was a patent agent during law school, but really dove into it in 2015. It started out with one or two clients that I mainly focused on for a few years, and then it's expanded to additional clients new clients and other clients within the firm. The the thing that I've seen over the last 5 years is that utility practitioners, or people who focus exclusively in utility and don't do any design work, are I think starting to come to realize that things are quite different in the design space, and that you definitely cannot have a one-size-fits-all approach for preparation and prosecution, let alone for searching, whether it's for validity searching, FTO, patentability. So that's been an interesting thing I've seen over my career at Quarles and Brady. The remote working, like Dunstan said, I'm lucky. I think a lot of firms were, well prepared to send attorneys remotely, but my firm was very quick to get support staff equipped to be able to work remotely. So relatively seamless, running full steam at this point, but definitely there was a transition there. And echoing Dunstan's comments, it's definitely hard to stay physically distanced, but doing the best I can, to keep inside and go out for. I don't have a dog, unfortunately, but I go for walks, so trying to stay sane.
Well, that's good to hear. Jeremy, would you like to give us a little brief intro to yourself that we haven't covered already?
My pleasure. I have been practicing in the design space for most of my 25 years of practice. I found it a great way to help clients round out their portfolios. I do find it's an incredibly nuanced area. I think just beneath the surface, you get a lot of unique perspectives from any given examiner at the Patent and Trademark Office that you may draw for your application. So there is a lot of strategy that goes into making decisions about what you put into a design patent application so that you have adequate fallback positions depending on what luck of the draw and what types of rejections and objections you might see to your drawings during the course of prosecution. And frankly, that's what's made Legal Advantage a great partner on the design drawing end of things, because they appreciate and understand those nuances and really help us to go in on the front end drafting more robust design applications, because you can easily find yourself in sort of the inescapable trap of an objection that you really can't find your way out of without adding impermissible new matter, which could be fatal to an application. So we're ever mindful of that. And I do think that the sort of casual utility patent practitioner doesn't always appreciate these nuances when they get exposed to design patents. I found it to be a really refreshing area and enjoy thinking sort of in a branding perspective, sharing as many of the clients' insights into their business goals with a product, and how helping them formulate a design patent protection strategy can bolster those branding objectives that they may have. And then as far as social distancing, it's been a little humbling because I've got 3 kids, so 2 of them in high school, 1 of them in middle school, and they realized that, well, if they can't be on the baseball team or the cross country team, we're going to have tryouts one way or the other. So they've put me through the gauntlet of cross country tryouts and baseball tryouts. So there's no dull moments around here.
Yeah, sounds very interesting for sure. Gentlemen, thank you so much for joining us. Of course, for anyone else following along with us, if you've ever been to a USPTO Design Day, you would recognize all of our members of our panel very, very quickly, of course, all very active in design space. So let us jump right in. I know we have a lot of material to cover, and a lot of it will be background information, of course, for a lot of the attendees today. In order to be able to receive the certificate of attendance for today's presentation, and we've applied for CLE credit. Once we do get the credit for it, we will send you the certificate of credit. We do request that you send us a email with your name and your bar number to the email address that's on your screen, search@legaladvantage.net. we will be giving a verbal passphrase. So at some point during the presentation, please write down that verbal passphrase and send the email to the email address that's on your screen. We'll send you a certificate of attendance for now, and then we will follow up with the CLE credit once the credit has been issued. Now, just to go over the agenda of what we'll be covering through our presentation today, we'll be looking at search types. Now, do keep in mind the CLE today is focused on design searching, where we will cover in section 3. We will start off with the different search types and their strategies and how to actually approach each search individually. Then we'll follow up with some databases. Now, there are many, many databases to choose from. Last I checked, there were over 2,000 databases to choose from. How do you select the right database? And so we've put together just a small list of databases, 5 free databases, 5 subscription databases that we would like to share with you and the capabilities of each one. And then, of course, the final section will have to do with the best practice search firms and inventors. What is supposed to be in a search report? How do you request a search report? How do you go actually putting all of the information that has been uncovered throughout the search in a timely and in a organized fashion that helps in actually portraying the information that was captured throughout the search? So we'll jump right in. Of course, we would like this to be as interactive as possible. So if you do have questions, please write them into the into the question bar in your right-hand side of your screen, and I'll make sure to ask our panel the questions. So let us jump right in. We have our search types and our strategies. Now, please do keep in mind that the search types and strategies in this case are focused a lot on the utility aspect, and there will be some design aspects as well. We will get into the heavy design part later on in the presentation. So why would you conduct a prior art search? Well, there are many different steps and many different places where you would request or inquire on a prior art search. Well, first and foremost, of course, if you're looking to file a patent, you want to learn more about the field of the invention, how to draft your claims. If a office action does come back with amendments required, well, then a search at that point would help you amend the claims. Understanding the competition that's out there. If you're putting a product on the market, that's a different type of search that will allow you to know what's out there and avoid infringement at that case. And then on a very, very broader scale, of course, getting an idea of what's out there, what the white space is. If you own IP, then obviously you would like to conduct a search to see who's using your IP without your knowledge or your permission. So many different steps, many different ways that you can conduct a prior art search to help with your business and business development. And of course, with regards to the attorneys, of course, understanding what's out there. And so usually searches would fall into one of these 3 major categories, whether it's prosecution, which is the novelty patentability type of search when you're drafting or amending claims, the competitive business intelligence, and these are the patent watch, looking to see what's being published into a certain field, or if you're looking for status change of patent applications, landscape analysis and seeing what's out there, or into the litigation or market analysis type of searches, which are the state-of-the-art freedom to operate and infringement type of searches. And so we're going to get into every single one very briefly. We'll start off with the patentability search. And of course, the patentability search, the main objective of this patentability search is to find prior art from either a single reference or multiple reference that can have an effect on this novelty that is going to be claimed or has been claimed. It offers the attorney a preview of the drafting and prosecution obstacles. And so you get to see what the examiners at the U.S. Patent Office will see before they see it. Or if you're doing it after you've filed, then you will see what they may come back with rejections with. So of course, in terms of the scope of where this is searched in all available resources, U.S. patents, foreign patents, non-patent literature. Again, we're looking for a single reference that can have all the aspects of novelty, or an obviousness of putting multiple pieces of prior art together to come up with that same concept. And so that's the patentability search. In terms of the litigation, validity and validity searches, of course, as their name would say, we're looking to invalidate claims of patent. And so immediately there is that train of thought that when you're looking to invalidate, you have to find art that was available before the priority date of that patent. And so again, we're looking in US patents, foreign patents, non-patent literature, and looking for art that can either a single reference has the elements that are of interest that can invalidate that specific claim, or finding multiple pieces of art and putting them together in obviousness, making sure that they were available before the priority date to invalidate the claim that is targeted. Now, when it comes to the strategy into invalidating a patent, of course, determining first and foremost, what are the claims that we are going to target, that we need to invalidate. Retrieving the file history, which gives you an idea of what this went from being a patent application to the date that it was granted. What history did it go through? And then, of course, with that being said, conducting these searches and constructing this forward and backward citations to put together a validity matrix. And so when it comes to the invalidity type of searches or validity searches, the two different approaches are the conservative approach of going after art that invalidates a specific claim at a time, or the more liberal approach of throwing a bigger net out there, capturing conceptual type of results and sending them off to litigation teams to determine relevancy. And finally, the competitive business intelligence, we were going to look at the landscape analysis in this case. And landscape analysis type of searches are completely customizable from start to finish, and they're really targeted on showing what is the target of the actual results, whether you're looking for a single patent or a patent family or related patents in that field, if you're looking at a patent portfolio of a company, or even in a larger scale, a technology or a sector to see who the players are and where they hold their IP. And with that being said, all the results that are captured and shown here for the landscape analysis will identify the relevant patents. The results are usually broken down by their assignees and technologies, and a lot of post-search analysis done here. Very, very quick search itself, capturing many, many results at a time, and then spending quite an extensive amount of effort to show why these results are relevant. And so we've put together a landscape analysis here put together by our team that will really show you what some of the capabilities are of this landscape analysis. Of course, the results can show if there is saturation in a market, or if there's growth, or if there's stagnancy. And so let's take a quick look at what one of these examples looks like. And in this case, we specifically looked for antiviral drugs due to the times that we live in. We searched the antiviral drugs going back 20 years. What's out there? Who holds this antiviral drugs? And on first glance, of course, it'll bring to your attention that a lot of these are filed in China by a long shot. And a lot of them are owned by Shanghai Boad Gene Development. Well, it begs the question of why? Why are there so many in China? And by far, well, we take a closer look at why, and we see there from the numbers that in 2001, China was admitted into the World Trade Organization. Well, that's when they were filing a lot of these patents. And then in 2003, there was SARS. And so a lot of the applications from that point, they were doing a lot of genetic sequencing, and every genetic sequencing, unique genetic sequence that they would find, they would file a patent for them. Now, a lot of those were rejected in the long run, but they were still showing up as applications at the time, and they obviously threw the numbers way off. But if we take that same set of results and we look at them in a sense of, let's see the ones that actually claim the term coronavirus or any of these other coronavirus type of strains. Now, keep in mind, coronavirus covers these MERS and SARS, the first two outbreaks that we had previously. And with that being said, you'll see that by far it's SARS-CoV that's being claimed, which is the first SARS outbreak that happened in 2003. But then if we look at specifically the IP that is claimed for coronavirus, the numbers look very, very different. If we look at that case, then we see that the United States Health and Human Services, by far the highest filer, followed by Johnson & Johnson, and then Merck & Company. And so then the view kind of shifts there in terms of the antiviral drugs went from being mostly filed and held in China versus when we look at these specific coronavirus drugs that are related to coronavirus, then we see that the US holds the majority of the IP in that space. And so here's a quick breakdown of when these were filed. And as you can see, 2019 was a huge spike in terms of the coronavirus filing. And so, of course, further breakdown is to look at these particular drugs and the clinical trials that they are actually being used in. And so that's what a landscape analysis allows you to do. It really takes a very, very broad look, and then it really breaks it down into its key components to see what these results actually mean. So before we continue into the search types and the strategies, we've covered the search types, and now we're going to get into the search strategies. Some of the key things to keep in mind when preparing for a search and the obstacles to overcome. We've put together a checklist here that will really help keep the workflow of the search from start to finish in a very orderly fashion, keeps you on track from start to finish. Of course, determining first and foremost what type of search needs to be conducted and where it needs to be conducted. Any date limitations, specifically, of course, if you're looking at the validity and validity type of searches, the freedom to operate, then the date restriction does play effect there. Of course, the databases, and then being familiar with the capabilities of each database. A lot of the databases, specifically the subscription, the more powerful type of databases, do allow you to do Boolean searching and truncations. However, the truncation does change from one to the other. If you're using an exclamation point or a star for that example, they mean different things for different databases. So of course, being familiar with how those happen. And then also keeping in mind that if you're searching foreign databases, then it's the format of the date limitation goes date, month, year, rather than month, date, year. So that's something to keep in mind. Now, before we continue, we do have the search strategies here that we're going to cover. Some of the issues that are encountered when you're actually preparing to conduct a search. And this takes quite a bit of time to come up with the search terms. And so how do you find the terms that are relative for the search? And again, we're going to focus on design searches a little bit later on. These are more towards the utility searches. And you do have to use key terms a lot of times in design searching as well. While coming up with the key terms sometimes is you don't know the terms, or certain terms have multiple meanings. They're used in many different contexts. Or language barriers for translations can change what a term actually means. And so, of course, you need to do your preliminary research, understand what terms are actually used, going to different patents that are within that same scope, very, very helpful in picking up those terms. And then also looking at the technology-specific databases. The databases that are written by the experts for the experts, they tend to phrase and term things a little bit differently than you would find in a patent or a publication for that matter. And so let's take a quick look at an example here of a face mask and how can we target a face mask? Well, you can use the term face mask. Can you come up with any other terms on your own that are covering this concept of a face mask? Well, we've put together a mask, face covering, breathing apparatus, face mask. But if you spend a little bit of time and actually find what kind of terms are being used in the art, you can find a lot more terms that you can put into your strategy that can help you bring back terms. Face mask, putting it all as one term, or face with mask. Putting a star or an exclamation point before the term mask allows any word to be before mask. So these are the additional terms that you can come up with fairly quickly when conducting a search and finding terms. And then, of course, we get to the context matters, which is when you're using a term that is pretty vague or has multiple meanings or different context usage, then you're going to be finding a lot of noise in your results and a poor quality of those results. And those usually are hand in hand. Well, how do you overcome that obstacle? And one of the ways that you can overcome that obstacle is not to take that term out. It is by linking that term to something that makes it relevant, whether they are the relevant classification codes or adding another set of terms that you can actually link to it to actually bring it into focus. And that way you're imposing on the search engine that when this term comes up, make sure that these other terms are associated, or make sure that these other classification codes are associated. And that brings your search results into focus. And in the most part, gets rid of a lot of that noise that is usually drawn in by those vague terms. And so in this case, if we're looking for a face mask, these are the classification codes that would be helpful, the cooperative patent classifications, that would be helpful to bring the actual search results into focus. Again, the international patent classification codes. So we have our US patent classifications, the cooperative patent classifications, and the international patent classifications. it's always a good idea to use an iteration of every single one, just to make sure that you're capturing it in case that there is a misclassification somewhere. So these are the classification codes that we would recommend there for face masks. And so we mentioned classification codes. In this case, we're going to look at the cooperative patent classifications. They're based on the international patent classifications. They were co-developed by the US Patent Office and the European Patent Office, and both entities switched over to actually incorporating these cooperative patent classifications. And they've also gone back in time and added these cooperative patent classifications to older patents as well. And so they're very straightforward in terms of how you can navigate through them. They're the section codes, which are A through H, and then they're broken down into their class codes, subclasses, main group, and subgroups within there. You also do have an option there, if you can see from the screenshot of the actual CPC website, you can actually search for classification by name. And so you can type that into the search box and it'll take you straight to that classification. And then finally, segregating the results. Of course, it takes quite a bit of time to read through the results. Important steps of the searching is spending quite a bit of time finding the keywords, making sure that the search is organized and flows in terms of the actual search on database time, and then spending quite a bit of time reviewing the results that have been captured throughout the search to make sure that you have captured the relevant part. And so that is the section regarding the search types and the strategies. Now, Jeremy, I know you wanted to mention something about the push to preliminary versus the prompting restriction when filing for designs. Would you like to cover that for us really quickly in terms of what that covers and what the different approaches are?
Well, sure. I think this is more of a prosecution strategy decision of when you are initially filing a design patent application. Do you file a single embodiment? Do you file several different embodiments? And if you do make the decision to file several embodiments, do you go in with a preliminary amendment and cancel all but one of those embodiments to avoid a restriction? Or do you wait for the examiner to make a restriction and then preserve the right to file divisional applications on non-elected? I was just interested in what other panelists do, and if anyone else on the line wants to ping in with their thoughts on it. That was one question that I had. And then, if I might, I think, Amir, you made a very interesting comment right at the beginning about pulling the file history. And I would say that whenever doing a freedom to operate opinion on designs, ever since the Egyptian goddess decision and even before then, but with the test being a test that looks at how an ordinary observer or hypothetical person familiar with the prior art would consider the design, it is incumbent to look at the entire file history in terms of what other art was cited against the design application by the examiner, in addition to the results of the search. So I just thought that has a particular relevance to the design end of things in terms of how the file history fits into the big picture.
Thank you, Jeremy. Dunstan, do you have any opinion on the question that Jeremy has posed with regards to push to preliminary or prompting restriction?
Yeah, sure. And I think a lot of it, the reason that it's become a question, a lot of it comes out of the Pacific Coast Marine Windshields Federal Circuit decision back in 2014, where there was this finding of prosecution history estoppel for embodiments that you did not, that a patentee or an applicant did not elect. And I think it's what it boils down to a lot of time, it's pretty situational. I mean, if I filed an application, I mean, there's no ban on me filing an application with a lot of kind of very different looking embodiments, if you will. And in that case, all of those embodiments, you're very likely to get a restriction. It would be bizarre if you didn't get a restriction between the very different looking embodiments. And there's probably no overlapping claim scope there. So in that situation, it's probably not, like, the strategic decision probably doesn't matter. I mean, anything you don't elect will necessarily be dedicated to the public. The danger in this windshields case is there were a number of different windshield embodiments that the patent examiner found to be patentably distinct, so issued a restriction requirement. Patentee elected one of them and did not pursue the other ones, and was found to have surrendered kind of the scope that was in between the embodiments, if you will. That's kind of a quick way of summarizing it. And so you want to be careful, I guess, in situations where you have multiple embodiments and there's maybe potentially overlapping claim scope. And I think in those situations, that's a situation where I definitely would look and consider doing a preliminary amendment, or possibly just filing with one embodiment in a main application and then using an appendix, which is something that's not specifically provided for in the MPEP, but it's also not forbidden in the MPEP, and there's a number of design patent practitioners that have been using it for probably a good 20 years or so now. So there are situations where it will come up, but sometimes it's really just not really a concern, and then in situations where it is a concern, I think it's definitely worth flagging and considering. So that's my take on it.
Thank you, Dunstan. Justin, do you have an opinion on this?
Yeah, hey, Amir. I would generally think about filing like this in 3 different buckets. We always file with an appendix. So, it's just a matter of what we would put in the appendix. If you're talking about 3 different designs, let's say, like Dunstan said, they're all very different. I would probably file all 3 as lead embodiments and then cancel 2 of them at the outset, assuming there wasn't a strategy in place to try to keep the 3 embodiments together, which that's another situation where, maybe we do have 3 versions of hopefully the same or similar article, and we're trying to keep them together. I might purposefully not file a preliminary amendment to try to keep them together. And then there's the run-of-the-mill, like for us, I typically file a single lead embodiment at the outset, and then file an appendix, which generally includes variations of that first design with boundary line additions or modifications to the design to show contemplated boundary line claiming. That's just to get over Owens, which seems to be, it seems where we are now is you can go from dash to solid, solid to dash. During prosecution, you just cannot add these arbitrary boundary lines. So we found that the appendix can be really useful for those types of situations where you can predict that you're probably going to catch a restriction if you try to keep them all together as lead embodiments. So it really just depends, I think, on what type of application it is. Is it just a run-of-the-mill, for maybe a high-volume client that you don't have a big budget to be thinking about, or trying to prospectively head off a restriction, or is it an important case where you're trying to really build out breadth and keep multiple embodiments together? So I'd say that it's less frequent for us, but I still do that every so often.
Thank you very much, Justin. We do have a question here. If you gentlemen would like to cover it really quickly. We have an attendee that's asking with regards to the rising masks, the demands and face shields. Are they actually stoking the sales of the counterfeit products? And what goes into the enforcement or restriction of these counterfeits?
So my take would be that one of the benefits of a design patent is you could actually have as the statutory damages the infringer's profits. So that's a stronger remedy than the typical utility patent infringement case that might limit damages to a reasonable royalty. There would be a question in terms of opportunities for injunctive relief, depending on whether the patentee makes the product, because if they make the product and sales of the accused infringing device are cutting into those sales of the patented product, then they have a better argument that they have damages that could not be compensated merely by money. You know, they may be permanently losing market share, for example. There's also sort of the social stigma now that we're seeing with some pushback. And, you know, I think companies do have to really think twice in this era that we're all living through as to how and when they're going to enforce their intellectual property. And I think that that's something that management should certainly be involved in those decisions, and marketing teams, and you know, it's really going to require, I think, in-house IP counsel to think differently with their teams, because they don't want to just have a knee-jerk reaction of seeing a competitive product that maybe is close to their patent rights and instinctively sending off a cease and desist letter, because that could be taken out of context and have some bigger negative ramifications for the company.
I know one interesting enforcement effort that's been in some of the news has been 3M has been, this isn't really concerning counterfeits, but 3M has been enforcing its trademark rights, specifically on the mark 3M on N95 masks that a sort of third party has been reselling at a high markup of 500 or 600% the cost that they are getting the masks from 3M. So I think it's just worth mentioning, because there are sort of sometimes creative strategies that can be used to enforce rights. I mean, obviously they don't have a trademark in the N95, but these are legitimate masks that were manufactured by 3M, and then someone's just trying to make a quick buck off of the masks, and 3M are using their IP rights to try and stop that happening. So no result on those cases yet that I'm aware of, but they were filed. I think there was more than one case filed last week, so definitely one to watch.
I'll just add that I have heard of, from a design standpoint, that certain companies are seeking or filing for designs on new designs related to these types of articles, with the intent to not enforce them, at least right currently, with the filing. They'll file it, let it go through prosecution, and hopefully get something that, remember, you can enforce for 15 years after the design is issued. So I don't see, as long as there's not an enforcement campaign that's being publicized, or you're filing lawsuits in this environment for use of these, I don't see any harm in, as long as you're keeping your powder dry, filing for and obtaining rights for these inventions or designs, because you never know what's going to happen in 10 years, and if your design is being knocked off. So yeah, those are my 2 cents.
Thank you. Yeah, and
I think
at least from my perspective, and I would actually like to pose this to the panel, is, I mean, there's a lot of technology that would go into these masks, and the fact that the N95 mask is the one that has been approved is because it's safer than the others in terms of being able to spread or contain the spread. And so doesn't that beg the question of, if they're using that name without having the technology and being able to do what the real one does, isn't that an issue as well that needs to be enforced?
Absolutely. I think if the public is associating that level of quality with the trade name behind it, that's certainly one of the things the Lanham Act is designed to protect the public from. So I think that would certainly be part of the complaint that the brand holder would assert, is the misrepresentation to the public that passing off claim would try to protect against.
Thank you, Justin. I know, Dunstan, you had something that you wanted to add on to this.
Oh yeah, I was just thinking off of Justin's point. I mean, of course, when it comes to obtaining rights, obviously, when someone has a right, they can choose what they want to do with it, right? So there are situations where people obtain rights and things and use them in ways that the public might perceive quite negatively. But I think, yeah, there's no real restriction here to getting them right and then using it kind of in a good way, if you will, and sort of maybe not enforcing it against people who are trying to do stuff that's benefiting what might be perceived as the public good. But if there are people who are producing counterfeit masks, especially ones of lower quality, I mean, maybe, design patents would provide another avenue where you could enforce that if they were infringing upon, rights that you did own. So, you could enforce it possibly through different parts under the Lanham Act, but also, having those rights, you might be able to stop counterfeiters who are making what might end up being dangerous products because they're being marketed or promoted as having properties that they just don't have. So it's just, another useful avenue to be able to stop bad actors, if you will.
Yeah, I'll echo all of that. It's a tool that can be used to hopefully be used for good to prevent counterfeit goods from being in the market. It's probably more difficult since it's less centralized, who's making these decisions to enforce or not enforce these rights. But, at the same time, it is a tool that can be used, and it's one of the few tools that that people have or that companies have to be able to try to help either protect their brand or protect the greater public. So.
And I just add, this is Jeremy, that there'd be a distinction because in the design patent realm, the patent owner actually has that discretion of whether to protect their patent right against an accused, a potential infringer or not. Whereas in the trademark realm, there's more of a duty on the trademark registrant to enforce that actively. And if they don't, they're at the peril of losing their right. So the design patent avenue, I think, does provide a greater level of flexibility even than trademark.
Thank you very much, gentlemen, for your insight. All right, we will transition into the databases really quickly and cover, again, just some major databases that are available for searching, some free databases, some subscription databases, and then we'll look at the pros and cons of each one and what they're able to do. Now, of course, we're only going to cover 5 of each, so it's not going to be an in-depth look, but it's going to give you a pretty good idea of maybe where you can do some preliminary searching, some background information gathering. So, of course, when it comes to searching patents and non-patent literature, there are many avenues that you can take to actually locate art. There are some that you can actually search simultaneously. Orbit is a great example where you can search for patents and non-patent literature, depending on what the target is. But let's take a quick look at the free databases that are out there. And we're going to specifically look at PatentScope, eSpaceNet, Free Patents Online, and Google Patents. Now, of course, you can see very quickly full coverage of the US and Japanese. Most European and PCT are covered in all of these resources as well. But of course, as you can see, the drawback there is that machine translation is not always available. Google Patents is usually a pretty good place. eSpaceNet is a wonderful place that always has these machine translations. However, IMPADOC family coverage is not available on Google Patents or Free Patents Online. And when it comes to the actual search engine and what you're able to conduct a search with, you can see that the forward and backward citations are supported on every single resource. However, eSpaceNet that we just mentioned has full coverage of all, and machine translations does not allow you to search using proximity operators, truncation, keyword highlighting, or user-defined highlighting. So these are things to keep in mind. Great resources for doing background information gathering, but in terms of being able to conduct a search from start to finish, may not be the best places to actually conduct the search. With regards to their interface capabilities, none of them are able to export your searches or import your list of references. So your search has to be done on the spot, completed on the spot, and then you cannot pick up where you left off if you are putting the search on hold or pause. But then again, great background information, has a lot of ability to search for designs in there. I know Google Patents allows you to search specifically for designs. So wonderful place to do some background information gathering. Now, when it comes to the subscription databases, we have PATSEER, Orbit, Derwent Innovation, and Relecura. And as you can see, full coverage of the US, the European, the PCT, and Japanese patents. Machine translations available for all documents, weekly updates, and INPADOC family coverage is included. With regards to their capabilities, you can see that the forward and backward citations, legal status, US, international, and cooperative patent classifications are listed for every document. Boolean operators and proximity operators are supported, and so is truncation. Now, with regards to the interface, you're able to save your queries, export your searches, import your list of references, export document data, and even download individual patents from the results. However, they do vary in their costs. And so this is the point where we've reached the certificate of attendance for the time being, and so we are accredited to provide the credit for the CLE today. Please send us an email, again, to the email address that's on your screen, search@legaladvantage.net. The verbal passphrase is, "It's a sunny day in Washington, D.C." That is the verbal passphrase for today's CLE. It's a sunny day in Washington, D.C. Please write down the verbal passphrase and send us an email to our email address that's on your screen. And I'll give you a second to write it down, and we will continue. All right, so let us jump right into design searching. And we would like to spend some time. I know, Dustin, I think you mentioned that you are familiar with searching designs in Orbit. Is that right?
Yeah, that's right. I think that's one of the main resources I would use myself if I wasn't to outsource a search to a vendor such as Legal Advantage. I think Orbit works pretty well. Obviously, when you're searching designs, you want something that's going to be able to give you visual results, and so it does a nice job of doing that, where you can you get a whole screen full of thumbnails that you can browse through.
Yeah.
So yeah, I think it's a good searching result.
Agreed. Thank you, Dunstan. So let us just really quickly jump into design searching. Of course, quite a bit of time spent in the first research part of it, finding the actual relevant class codes. However, design searching is one of those type of searches that just takes an extensive amount of time once you're actually flipping through the results, as Dunstan just mentioned, being able to find the elements of the design interest that you're looking for. And so the US has 33 major design classifications, and Locarno have the 32. They're very, very close in terms of their classifications. As you can see there, the US patent classifications and the Locarno patent classifications, design classifications. And so let's take a look at the 3M N95 mask. And so we did a search for the N95 mask there made by 3M. And as Dunstan mentioned earlier with that trademark, having these 3M N95 masks being sold as 3M N95 masks, even though they were bought from 3M, the trademark issue there of using the name 3M to sell them at a higher cost. This is what the 3M N95 mask looks like. And the classification codes, of course, that are associated with it are found in the Locarno classification codes 24-02, 24-01, 28-03, and 29-02. In terms of the US classifications, they are D24/111, D29/100, and D29/108. So that's the N95 mask specifically. But if you look for just those classification codes in particular, you'll find results that obviously have nothing to do with the N95 mask, as you can see there with the mask that shows up on your screen. Very, very different designs. However, they are all under the same umbrella of the design that covers the N95 mask. So obviously, a lot of flipping through those results to make sure that the search is actually capturing the relevant results and flipping through to find the elements of actual design there that are of interest. Now, we did mention using keyword searching there to narrow down results. So if you do find the classification codes and the design codes and you're looking through them, and finding a lot of noise in there. You can always add in key terms that are relevant that will bring the search into focus. Again, narrowing the scope to be able to find the ones that are actually of relevance to you. Now, that's not always a single strategy in terms of searching, only using classification codes, design codes, and keyword searching. Obviously, there are some that will not have the keywords that are attached to them purposely, and you don't want to miss out on those. So obviously, there is the time that needs to be spent into looking at every single reference in that design classification. And so we've reached our last section here, which is search firms and inventors. We do want to have a little bit of time at the end there to have Q&A with our panel. Best practices, search firms, and inventors. And we're going to cover some of the key components of a search report. We'll show you an example of what our search report looks like, and really some of the information that is extremely helpful when requesting a search to make sure that you are given the results that are of relevance to you. Now, of course, a search report is supposed to highlight the information in a very organized fashion, provides you an organized table of results with all relevant publication information, patent number, issue filing dates, legal status, asking the applicant information, along with the drawings and illustrations specifically for designs, and then also mentions all the other aspects that were included throughout the search. The report is supposed to give you a summary of the prior art that was uncovered throughout the search, providing you, again, the highlighted information in a fashion that will bring your attention to that section that is highlighted to show you which aspect of that prior art reference came back as a positive hit on the elements that were required. And so here's what a report looks like with regards to a patentability search. And as you can see fairly quickly, the date that the search was provided, the key elements there, immediately what the search was looking for, and a summary of the results that were uncovered throughout the search. 10 patent references, 2 non-patent references that were immediately uncovered throughout the search. Providing you, following that, a list of details regarding the search, the date that the search was conducted, the date restriction, if any, databases that were used, and then a list of the keywords or main elements that were searched throughout the search. Following that is the list, the table of results, providing the results in order of relevancy, with the patent publication number, the title, the publication or issue date, ASICME information, and inventor information. Now, with that being said, each result is further then broken down into its key components. Each one is provided with an excerpt of why this result was a positive hit. And as you can see, each result is shown with the highlighted text that is of relevance, as you can see, bolded and italicized to draw your attention to that term and show you where this came up in the actual result. Again, providing you the publication information, the application or patent name or number, the title, and the publication date or patent date. With regards to the non-patent literature following the patent results, again, publication information with a link to the result, so you can actually click on it and see the actual report itself, with, again, an excerpt from the results to show you bolded italicized text of why this result was deemed a relevant result. Following that is the list of classification codes, keywords that were used throughout the search. And so when you're requesting a search and when we're conducting a search, of course, the best practices there and being able to make sure that your search is going to find the results that are of relevance is to provide as much information as you can with the request. Any illustrations, any possible art that you have already and what it's missing. The point of novelty, make sure that it's completely understood, and then giving any priority dates that are of interest that need to be adhered to throughout the search as well. With that being said, what are some of the benefits of hiring a search vendor? And so I would like to turn it to the panel. I've put together a short couple bullet points here of why it would be helpful to do a search with a search vendor rather than maybe doing them in-house. Dunstan, would you like to just cover for us some of the benefits that you've had from sending searches to a search vendor?
Yeah, I'd be happy to kick it off. I know certainly sometimes in terms of budgeting, you know, the client might have a specific budget and it might just make more sense to have a search vendor who specializes in searching conduct the search, spend a specific amount of time rather than having an attorney or even sometimes a group of attorneys do the searching. So it just might be more cost effective. There's probably situations where vendors will have better tools for searching. So, perhaps they might have tools available beyond something like Orbit that might be advantageous. Or if you're in a situation where you don't have Orbit available, then or something similar, maybe you don't have the capabilities to do the searching that's required in-house. So just makes sense to send it out. I'll hand over to Justin and Jeremy if they have other thoughts as well.
Thanks, Dunstan. I'll jump in. Yeah, I think that each situation is different. Some clients, it's just in their process where an FTO or a patentability assessment is provided to the law firm, and they expect that the law firm is going to farm out the search just to make sure that everything is looked at by a second set of eyes or third set of eyes before it's reviewed for freedom to operate or patentability. With respect to certain things like a validity search, that's something I definitely would recommend, farming out to a vendor like Legal Advantage, who I use for most of my work. So you guys do a great job. But it's one of those situations for a validity search where you could spend, hours and hours and hours of an attorney or a patent agent or whoever's conducting the search in the law firm. Whereas a search firm that has access to all of these databases might be able to be much more efficient with a search like that. So each situation is different. We definitely do a fair amount of searching in-house, but it's typically for more isolated projects that maybe just require a couple hours of searching compared to the typical amount of time that's put in by Legal Advantage or a similar search firm.
And then one other situation I could see being a good justification to have an outside search vendor would be if an applicant is interested in expedited examination of their application. The patent office has a procedure for expedited design patent applications that does require some level of ex parte searching on behalf of the applicant. So it's just nice for the attorney to say at the time of filing that this search was conducted by a professional patent searching vendor and that these are the results that were found. And I think that bolsters the credibility of the request for expedited handling of the application. So that's more likely to be granted.
Thank you very much, gentlemen, for your input. Yeah, I mean, I was going to cover exactly the same information that you just mentioned with regards to the time is usually the hardest thing that you can give up. And of course, attorney time is quite important there with regards to spending the time actually searching. Just a quick example there with regards to a design patentability search, for example. In our search team spends at least 18, 19 hours on a single design search. And so, of course, translating that to attorney time, of course, is something that we don't want to get into at this moment. But just to give you our team credentials, of course, over 80% of our team members have a master's degree in the art that they search in. Over 40% have either dual masters or a PhD. Combined search experience, of course, well over 22,000. I think I have close to 10,000 on my own. Cover all the majority of the search domains. And so now we've reached the section of questions for the panel. I've put some questions together for the panel. If you would like to take a second to spend some time with us to go over some of these. And so I'll start off with Jeremy. If you could make changes to the process of protecting or enforcing design IP, what would those changes be that you would implement?
Well, I would like to see a bit more transparency, particularly as to that question we raised before about restriction practice. There's not a lot of objective criteria currently at the Patent Office in terms of when it is decided to require restriction of plurality of design embodiments that are included in an application and when not. There's sort of a loose standard that's put forth in the MPEP about whether the designs would have been obvious variants of one another. But I think there could be more transparency, at least in the manner in which design examiners are trained to make that call. And I'd like to see a little bit more of that shared with the design bar.
Thank you, Jeremy. Justin, would you like to maybe give us some of your insights, some of the things that you, if you could make changes to the process of protecting or enforcing IP, design IP?
Yeah, I would say there are certain areas of the law that we probably need a bit more guidance from the CAFC, and this is probably going to take years of fact patterns making their way up. Which it's good that the courts seem to be getting more involved in design issues, and hopefully over the next decade or so, we'll be able to, flesh out some of these issues, with respect to novelty, 102, the difference between that and 103, the kind of built-in doctrine of equivalence, and all of that then with respect to infringement. I know there are a few cases up at the Court of Appeals or that we're following in the district courts where non-infringement has been found. I know there's at least one case, the Pencil case, the Lennard, I think it's called. I look at that case and I think that it's, even looking at the prior art, that it's a dead-on infringement, and the district court judge, I think on motion for summary judgment, said non-infringement. So things like that, I think we just need some more guardrails with respect to infringement, and then laying out, I guess, a little bit better the 102, 103, and the differences between the two, because it actually seems like it's harder to make a 103 rejection now than a 102 rejection. So, I think it's a really interesting area of the law, and it's developing pretty quickly, seemingly, compared to like the last 80 years. But yeah, we need a little bit more clarity on some issues.
Thank you very much, Justin. Dunstan, do you have an opinion on this at all? Are there any?
Yeah, I think there's probably quite a few. A couple I'll touch on, following on from Jeremy's point. I think one area that we'd like to see more guidance, both patent practitioners, design patent practitioners, and examiners, is with respect to Section 112. A lot of the time, it's pretty like the same issue that Jeremy was describing with respect to restriction. It's pretty subjective as to whether something's adequately disclosed and described. So if you're filing like a continuation application, and some of this builds on what Justin was saying with using certain boundary lines and appendix embodiments, there's just there's just examiners in my experience, they tend to have very different opinions as to, which is totally understandable because reasonable minds can differ. But the result is, for applicants and probably the general public as well, it's very unclear as to, it's just sort of inconsistently applied, sort of Section 112 analysis. So I think it would be nice to see a little bit more guidance. It might be a kind of a hard thing to put together, and I think that's why we probably haven't seen it. I know that for the past several years, I think there's been the suggestion that some sort of guide might come out to give examiners and then obviously practitioners a bit more guidance as to how things are being applied. We haven't seen that to date. So that would be one area. Another area I would love to see more on the litigation side is just this idea of functionality being used to limit, I guess where it's used most of the time is these days is limiting the scope of a claim, with the idea that you kind of factor out the functional elements of a design. And I just don't really like that. I don't think it's necessary, I guess, for the first part. I mean, you can have, design is necessarily, if it's protected by a design patent, it necessarily has some function. Otherwise, it would be the realm of copyright. And obviously, you don't want to extend designs that are solely dictated by function. That's kind of like an initial 171 bar. But I think we got this, there's this sort of doctrine that's grown out of I think probably some kind of sloppy language from cases like the odds-on decision, and even there's a passage in Egyptian Goddess that sort of led to this idea that for claim construction you have to factor out any parts of the design that are functional. And it's just, it looked like we're moving away from this. The Federal Circuit has tried to, I think, correct the issue, because it really came to a head in there's this Richardson decision where I think effectively you maybe end up with a design that has no scope, which just, because every part of it has a function. So it's just kind of led to some absurd results, and that's another area that's being really inconsistently applied by district court judges. And I think, you know, with good reason, because the law is kind of unclear. But I think it's just something you could get rid of if you're worried about the overreach of design patents. There's ways of limiting it without playing this sort of absurd claim construction game. So those are just a couple areas. I'm sure there's other areas that could be improved, but again, it's a pretty interesting space to practice in and do searching in. So plenty more that could be said.
Thank you very much, Dunstan. So I know, Dunstan, you mentioned Orbit. Jeremy and Justin, are there any resources that you like to resources that you like to jump to really quickly when you want to just have a quick look? And are any of them a surprise to maybe any of us?
I would say one that maybe doesn't come to mind necessarily, but I'll go to now and then, is the Hague's resources. Every now and then I'll be curious as to what designs a particular assignee has had granted, and I won't necessarily stop at what the USPTO assignment search says, but I'll go on to the WIPO site and see if they filed any Hague applications that have maybe published. Maybe they haven't designated the US, but they designated other countries, and that could be an indication that there's sort of a submarine US design application out there in the wings. And every now and then I'll find a nugget there that I wouldn't have otherwise found.
I'll just, I wouldn't say that there are any particular, resources. I generally use Derwent, PatSnap, Google Patents when I'm doing searching. And if I'm doing a design search, I might start with a utility search of a similar device just to try to get nomenclature down before I start doing searching. But and you touched on this, Amir, about building out the keywords before you do searching. That's where I'll start for anytime I'm going to sit down and do a couple of hours of searching. Really get the verbiage down about what it is I'm focusing on, what are alternatives, so that I'm not, because at the beginning of my career, I found myself doing this. I did find out, a couple of hours in, that I had maybe not been targeting the correct area, and all of the searching I had done maybe needs to be done again for including, another word or another couple of words. So getting that down at the beginning and maybe figuring that out first before even looking into the art, I found to be helpful.
Thank you very much. I think we ran over a little bit. Any final advice, Dunstan, that you'd like to give anyone that's joined with us today?
I guess stay healthy and safe and sane. In terms of design searching, I think there's plenty of resources out there, and Legal Advantage is always a good starting point. But thanks for joining the call.
Thank you very much, Dunstan. Justin, would you like to give us any final advice to all of us that have attended and your peers?
Yeah, I mean, I'd say if anyone's listening who's kind of new to this, it's definitely it's not like utility. You got to do it to learn it, and just more practice and looking at lots of different designs and trying to figure out how to bring everything together. It takes time, so I guess just patience if you're new to this.
Thank you very much, Justin. Jeremy, any advice?
I'd say make yourself aware of the Federal Circuit's decision in Kerr Luxembourg. I think it is a bit of a game changer now that design patents will be evaluated in terms of scope based on the language that's used in the wording of the claim. Typically, the claim of a design patent application is not given too much thought, and I think that is going to be litigated more and more, and I think we can, as practitioners, do a good job for our clients by making sure we understand the scope of the particular product that they're trying to protect with this design, and make sure that the language that we're using in that single claim is going to be broad enough to do what it needs to do to protect them for the term of the design patent. And thanks again. Stay safe, everyone.
Thank you very much, Jeremy. Gentlemen in the panel, thank you so much for spending your time with us today. But, we're forever grateful to you with the amount of knowledge that, of course, you're willing to share with us. Thank you so much for your time today.
Thanks, Amir.
All right. Thanks. Bye.
Thank you.
Thank you very much. We're going to go ahead and end our session for today. For all of those who attended with us today, thank you so much for your time. Of course, again, thank you very much to